Today, Attorney General Eric Holder was on the hot seat in the Senate Judiciary Committee and, by most accounts, did not acquit himself terribly well. The reason he did not do so well is because, frankly, he was trying to defend the indefensible, namely his decision announced last Friday to move Khalid Sheikh Mohammed and four of his alleged co-conspirators in the murderous attack on the United States in 9/11 to the city that suffered most grievously from those attacks, namely New York City. This is a mistake on so many different grounds that, frankly, it's almost hard to believe that anyone is serious about trying to defend it. The reason being that it seems as though it has as much to do with President Obama's decision to close Guantanamo Bay as it does with the merits of this particular course of action. After all, if the worst of the worst of the worst can be brought to the United States for trial, as Mr. Holder believes, then surely everybody else can be. And for the variety of reasons that I want to just enumerate for you, that's not correct. And it shouldn't be driven by a decision to close Guantanamo Bay. In fact, to the contrary, we should be preserving that most secure, most efficient facility for housing such terrorist detainees. And remember, as unlawful enemy combatants, under the Geneva Convention, they're not entitled to any judicial review. This is a matter that has become garbaged up as a result of successive U.S. judicial rulings. But in point of fact, Khalid Sheikh Mohammed, the alleged mastermind of the 9/11 attacks, the man who claims to have murdered with his own hand an American Wall Street Journal reporter, Daniel Pearl, is a guy who should be treated as President Obama says he intends to treat scores of those now held in Guantanamo Bay, namely to hold them indefinitely without trial. That seems to me to be the appropriate course of action here, not putting him on trial, specifically not putting him on trial in New York, and specifically not putting him on trial in New York in a civilian court, for, among others, the following reasons. First of all, the moment Khalid Sheikh Mohammed and his pals arrive in the United States, they will be imbued with constitutional rights to which they're certainly not entitled, but from which they will extract considerable benefit. Not least, they will be getting the best defense counsel in the world. People, for example, who work for Eric Holder's former law firm and others of the so-called Guantanamo Bar, who have been assiduously defending these detainees in such proceedings as have been held to date, but who will be all over both the media and the courts in America if they are brought here. Among other things, these defense lawyers will be trying to free their clients, which means in turn, in all likelihood, turning them loose inside the United States. You think that's unimaginable? Well, think about the following. They will be claiming that they were not read their Miranda rights. Well, of course, they didn't have Miranda rights at the time, but that was then, and this is now. If they come to the United States, you can bet some federal judge is going to say, well, why weren't they? Never mind that it's time of war, never mind that the forensics and other technicalities of criminal procedures could not possibly be applied by our military forces in apprehending guys like Khalid Sheikh Mohammed. Then there's the question of if they can, the defense is going to try very hard to compromise sensitive intelligence sources and methods. This is a well-practiced technique calculated to increase the costs to the government of these prosecutions by, in effect, increasing the damage done to our national security. Similarly, these defense lawyers will be insisting that by virtue of the enhanced interrogation techniques to which Khalid Sheikh Mohammed has been subjected, including, by some accounts, waterboarding on 183 occasions, these guys should be turned loose. They should not certainly be prosecuted, at the very least on the basis of any evidence that they might have given subsequent to what President Obama and Attorney General Eric Holder have, let's be clear, called torture. I wouldn't be surprised at all if these defense lawyers don't insist that the President and the Attorney General come and appear themselves as defense witnesses for the purposes of illuminating the torture to which their clients have allegedly been subjected. In other words, we're going to find, I think, a whole host of reasons under which there will be problems with the prosecution of these guys. And then there are other procedural challenges. We may well see the defense claiming that there can't possibly be an impartial jury impaneled in New York City, which will mean, quite likely, the transfer of the case elsewhere. Almost certainly to less secure facilities. But even if the facilities themselves are secure, wherever they are, whether it's New York City or someplace else, there's a distinct possibility that the surrounding communities, which are inherently soft targets, will also become higher value targets to terrorists. This has caused people in New York City, particularly, on all sides of the political spectrum, to be horrified at what the Attorney General has decided to do to them, to their city, and quite possibly to our country. And that would also be the case in cities elsewhere, including in northwestern, I guess it is, Illinois, where Senator Durbin and others are now urging that Gitmo detainees be moved. Even if they can be held securely, even if there is not a danger to the civilian population surrounding the prisons wherever they are held, there's a further problem, which the FBI director, Robert Mueller, has called attention to, namely that these terrorists, these rock stars of the terrorism business, will assuredly be able to influence, to recruit, to indoctrinate, to train prospective jihadists inside our prison systems. And this is not a hypothetical concern. Several of the recently discovered and happily aborted terrorist attacks that have been uncovered in this country in recent months involve people who came to jihad and Sharia, which commands it, in our prison systems. Now, to be sure, there is a chance that if Khalid Sheikh Mohammed goes to trial in the United States in a civil court, he may well confess again, as he did once before. But he might not. If he does not confess and he goes to trial, he may well be convicted. And if he is convicted, he may well, after many years, ultimately be executed. But the truth of the matter is there are real risks associated with trying to get to that outcome, including the distinct possibility, in fact, I would bet it's about an even prospect, that this guy gets executed for his crimes on the one hand and walks free, perhaps in the United States on the other. Those are risks that are simply way too high. One thing is clear, however, already. Neither American values nor the families of those who lost loved ones on 9/11, nor the rest of us will be well served by the fulfillment of the Attorney General's plan to bring Khalid Sheikh Mohammed and his co-conspirators to New York City, where they will be able to wage both lawfare and political warfare against us. I personally believe that the right answer for Khalid Sheikh Mohammed is, as I said, to lock him up and throw away the key, as President Obama himself has said he intends to do with a number of his other detainee friends. But it is both a travesty and potentially a highly reckless act to pursue the course of action that the Attorney General has offered, and that, I'm sorry to say, several conservative figures, including Grover Norquist, have encouraged others to accede to. Not a good idea. Not a good idea for our country. Not a good idea for our citizens. And I hope that this will become a rallying cry for not only people in New York City, but Americans all across this country who recognize that we must not allow this kind of new act of terror, for that's what I'm afraid it will become, to be perpetrated on our watch.